Okay, so as I mentioned earlier, our guest speaker today is Nancy Friedman, President of the Greater Houston Area Chapter of Americans United for Separation of Church and State. Nancy has been President of the Greater Houston Chapter since spring of 2011 and was elected to the National Board of Directors as well of Americans United in the fall of 2011. Nancy has also served on the board of the ACLU of Texas since 2003, and she has a law degree from the University of Texas School of Law. In 1994, Nancy founded Let Freedom Ring, an organization dedicated to promoting and preserving separation of church and state, individual liberty, and freedom of expression in the Houston area. Nancy will be speaking to us about current and prior cases involving separation of church and state that Americans United has been active in both at the state and national levels. So please welcome our guest speaker, Nancy Friedman.
Thank you, Vic, for inviting me to come speak to your organization. I'm always happy to have the opportunity to talk to everybody, to let people know about the great work that Americans United is doing. I recognize some of you as members of Americans United, but I bet some of you are not familiar with it, so I just want to tell you a little bit about the organization. Americans United for Separation of Church and State is a nonpartisan, nonprofit 501c3 organization just like yours. It's an educational organization that's dedicated to preserving the constitutional principle of separation of church and state as the only way to ensure religious freedom for all of us living here in the United States. Americans United probably has one of the longest, if not the longest, names of any nonprofit organization, so we usually refer to it as AU. AU is based in Washington, D.C. Like the Humanists, it has local chapters in various parts of the country, including the one that we have right here in Houston. Founded in 1947, AU works in the courts, in Congress and in state legislatures, at the White House, and in the arena of public opinion. Now, as Vic said, I've been asked to talk today about some of the work that AU does or has been doing recently in the courts, both at the national level and here, so I'll do that. But first, I want to give you a little overview of AU's legal program to explain to you what it does and how it does its work. AU is contacted daily by individuals from across the country who believe they have either been subjected to or witnessed potential violations of the First Amendment. In fact, last year AU received about 1,000 complaints. Now, not all of these complaints reveal true violations of the First Amendment, and some of the complainants, after they contact AU, decide that they'd rather not be involved. When AU contacts them to ask for more information, they decide, perhaps out of fear of repercussions in their communities, that they'd rather leave it alone and not get involved. But of those complaints that do have merit, AU typically tries to remedy them by non-adversarial means. Members of AU's legal department engage in what they call informal advocacy, writing letters, making phone calls typically. They do this in an effort to try to remedy these violations and to educate school officials, legislators, and others about the constitutional requirements. These efforts are sometimes undertaken quietly without any publicity. Some of y'all were talking about whether you should publicize your efforts. Well, sometimes AU decides it's best not to publicize the efforts, and often that's to protect the complainants, who often remain anonymous. Now, this informal advocacy is very effective, actually, and it's usually as one of the best ways to resolve complaints. As a recently retired trial lawyer, I can tell you that filing a lawsuit isn't necessarily always the best way to resolve a dispute. Lawsuits can be expensive. Lawsuits can take a lot of time. You'd be surprised how long some of these cases take. When I used to meet with my clients and they'd say how long it'll take, and I would say, well, we're maybe looking at a trial date in 2 years. If we're lucky, they would be astonished. An amicus brief or a friend of the court brief in cases that are up on appeal, in cases in which there's an issue that's of interest to AU. Now, I want to talk to you about some cases that are either new or were concluded last year in 2012. I'm going to focus on Texas cases, but I'll talk a little bit about about some cases that came from outside Texas that are significant to us. And let me give a couple caveats. First of all, I am a lawyer, however, I'm not a constitutional lawyer. So I have certainly researched these cases and the facts of the cases, but if you have any kind of questions about constitutional arguments, I may not be equipped to talk about it. And second, I think that a lot of us believe that the best speeches are those that are sprinkled with humor. We all remember Herb Silverman's talk that was very entertaining, in part because he was very witty. I think in this case, I'm going to let the humor come from the participants in the lawsuits. And some of those I was hoping to show you visually, but I could talk to you about them. And when I say amusing, they may not be laughing out loud. You may find them sad rather than funny. But it depends on your perspective. Some of the comments are very ironic, and some of them can be amusing. Now, the first case I want to talk to you about, and the first type of case I want to talk to you about, is the public schools. Public schools are one of the main fronts in AU's effort to preserve church-state separation. And student prayers at high school graduations is one of the biggest areas in this field. Schultz versus Medina Valley Independent School District is a Texas case that is very important, that was finally resolved last year, and that dealt with this issue. I'm going to talk for a little while about this case, probably more than any of the other cases, both because I think it's interesting. I think it's illustrative of a lot of the issues that arise in this kind of lawsuit. Now, the Schultzes, who are the named parties to this lawsuit, live in Castroville. Castroville is a town of around 3,100 people near San Antonio. The high school principal there would talk about God over the intercom in the mornings, and he'd ask for God's blessing for the various sports teams at the school, for the troops, or according to Mr. Schultz, whatever was on his mind at the time. The family complained about this to school officials, and initially the school principal apologized and stopped this behavior. But more religious activities started occurring, and so the family contacted AU. Now, this is an instance where AU's efforts at informal advocacy were not effective because the school district, in response to letters from AU, did not stop these practices. So AU filed a lawsuit on behalf of the family 1 week before the graduation. AU filed this suit because at that time, because the district intended to present at least 2 prayers by students at the graduation. The Schultzes, who were agnostic, had sat uncomfortably during the elder son's graduation during these prayers, and they didn't want to have to go through that again. So AU filed a suit on their behalf. Now, at first, everything moved very quickly because, as I said, this lawsuit was filed 1 week before graduation. The trial judge held a hearing a few days after the lawsuit was filed. The next day, the judge issued an order in the Schultzes' favor. He ordered that official prayers had to be removed from the ceremony, and that the students had to be told, the students who were to give speeches had to be told that they could not attempt to lead their peers in prayer. Well, the school district immediately appealed the judge's ruling to the U.S. Court of Appeals for the Fifth Circuit. That's the intermediate level in the federal court system. And the district sought an emergency ruling. Texas Attorney General Greg Abbott sided with the school district, as you might expect, and his office filed an amicus brief with the Court of Appeals. He argued that the prayers were student-initiated and not school-sponsored, and he couched this as a free speech case, a case involving the speech, the right to free speech of the students involved. The class valedictorian, who was set to give a speech, also filed an amicus brief because she said she was planning to pray and she wanted to be able to pray and include Amen and in the name of Jesus in her speech, but the order restricted her from doing that. And she complained, I had hoped to use prayer to encourage my fellow graduates to trust God's plan for their lives, but because of the judge's ruling, I won't be allowed to do so. Well, 2 days later, the Fifth Circuit overturned the trial court's decision and allowed the prayers to go on at the graduation. Now, since this ruling came late on a Friday afternoon, the day before the graduation, AU had no time to do anything. At the graduation, interestingly, the district did remove the words invocation and benediction from the program, the ceremony program. And a student gave what were labeled opening remarks that began with, those who wish, would you please pray with me? But according to a San Antonio newspaper report on this graduation, it seemed more like a prayer rally than a high school graduation. State Representative John Garza of San Antonio said during his remarks, "The judge of all judges commands us to pray," adding that his daughter had invoked God while she graduated the year before. He said, "I still cringe thinking some left group would complain or file a lawsuit. I thank God that all is well this evening and none of us will be thrown in jail." And applause erupted from the packed football stadium with each amen. And the valedictorian who had intervened in the case, she got her wish to lead the attendees in prayer, thanking God for the freedom to be here today. The newspaper quoted one parent of a graduate who said he believes wholeheartedly in separation of church and state, but he also supported the valedictorian. He said, quote, "You don't trample on First Amendment rights to appease the separation of church and state." He went on to say, these were her words, "If the boy didn't want to hear it, don't listen or don't come." But he did become valedictorian. So remember that. You only get to assert your rights if you're the valedictorian, if you're the boss, whatever. If you're not the one in charge, according to this guy, you have no rights. Now, the high school senior, Schultz, who was one of the plaintiffs, didn't attend the graduation because of concerns about the security of him and his family because they had been harassed by people in the community and elsewhere. But they weren't the only people who were harassed because of this order. Y'all might remember Newt Gingrich back in October of 2011 talking about judges who should be held to account for rulings like this. He said they should be, in fact, arrested if necessary to compel them to come to explain to Congress why they would issue rulings like this. Well, the judge that he was talking about, in fact, the judge that he actually named in campaign speeches and in an appearance on Face the Nation, was this judge who issued this order. And the judge was condemned by a lot of people. Some people prayed for his death. And so he requested and received protection from the U.S. Marshal Service. Now, as this case progressed, AU found out about a lot of problems where school officials, teachers, administrators, coaches had been promoting Christianity for years, both during the school day and at after-school activities. In addition to saying prayers over the intercom and at school activities, there were religious displays throughout the school classrooms, such as a poster of the Cowboys' 10 Commandments. And that featured rules such as put nothing before God and no fooling around with another fellow's gal. Now, last February 2012, the parties settled the lawsuit. And the settlement was on terms favorable to the Schultzes. The school district agreed that its employees will not initiate, solicit, or direct prayers, won't join students in prayers, won't proselytize, and won't invite others to engage in these practices. And the district will not invite speakers whom it has reason to believe will proselytize or will promote religion during their remarks. And the school district agreed it will no longer designate student speeches as invocation or benediction or use other religious terms. Now, after this case was settled, AU had better results with its informal advocacy with other school districts along these lines of school-sponsored prayers and graduation ceremonies. Y'all might have heard about the case in Poteet, Texas in May last year. That's another town near San Antonio. Many of these, frankly, I'd never heard of until these cases came up. A student at Poteet High School contacted AU to complain about his high school's long-standing practice of having invocations and benedictions at graduation.
Could you repeat the name of the school?
Poteet, P-O-T-E-E-T.
Thank you.
What's more, in this case, not only did they have the student prayers, but school administrators told the students who were supposed to give the prayers, or I should say, told the students that were supposed to speak at the ceremony that they had to write and deliver prayers, and that the school had to approve the prayers before the ceremony. Now, AU wrote the school officials explaining that this was all unconstitutional. The school actually heeded the letter, and so what they did was they told the students, in an attempt to rectify the problem, that they could opt out, and the school would just choose other students to deliver the prayers, like deliver the prayers. Well, AU then wrote a second letter explaining that this really wasn't a good solution. In fact, it wasn't a solution at all to this problem. And they couldn't condition the students' right to speak at graduation on the students' willingness to write and deliver a prayer. So ultimately, the school changed the invocation and benediction to opening and closing remarks and removed the requirement that those remarks be prayers.
All
And
right.
another instance of successful non-litigation advocacy. in May, AU received complaints about a number of violations at Irving ISD, and that's outside Dallas, and such as the district sponsorship of a baccalaureate ceremony. After receiving AU's letter of complaint, the district investigated, addressed AU's concerns, and stopped many of the practices, including having the baccalaureate ceremony. Now, AU halted other unconstitutional acts in Texas in the public schools last year through this informal advocacy. I want to tell you just about a few of them. In Denton, a public school hosted an assembly featuring a religious group known as Team Impact. The in-school presentation was secular, but this group invited students to come to an after-school religious presentation. AU wrote the school district explaining that it's unconstitutional for the school to allow a group such as this to use a school event to invite students to a religious activity. The school district agreed and spoke with the principal and made sure that this won't happen again. In El Paso, it turns out that 4 school districts in El Paso had for several years bused students to a church, same church every year, where the students saw a religious play and were given toys because it was around Christmas time. Parents weren't supposed to sign permission slips, but apparently those permission slips did not mention that this was a religious play. And in fact, some of the school administrators later said that they had no idea it was a religious play, but of course somebody at the church said, well, this is a church and this is Christmas time, so yes, what we're doing has some religious content. Some parents wrote AU to complain about this practice, and so AU attorneys wrote officials at the 4 school districts involved, again explaining why this was improper and in fact unconstitutional. 3 of the districts said they would discontinue the practice, while the 4th district, the largest district, claimed, as I said, that they didn't know it was religious and they would review the policy. And one more that is one of those that's kind of an amusing story is an incident that happened in a town called Mercedes, Texas, and that's down the valley in Hidalgo County. Here, a high school teacher displayed 2 things in his classroom. One is, or was, a nativity scene, and the other was a doll of the Grinch. During class, he pointed to the nativity and declared that it was for those who shared his Christian faith. Then he pointed to the Grinch and said that it was for all those who did not.
Oh.
AU wrote a letter to the district explaining that it's unconstitutional for a public school teacher to erect religious displays in the classroom and to make disparaging comments about minority religions. Again, to its credit, this district promptly removed the displays and assured AU that they had discussed the matter with the teacher. Another area that draws a lot of complaints in the public schools is public school graduations held in churches. This is happening here in Texas, as a matter of fact. There were 2 cases where AU prevailed on this issue recently. Neither of them was in Texas, but I want to talk to you about them for a few minutes because this issue, as I said, does arise here, and these 2 cases could have some precedential effect here. One of the cases was in Wisconsin, one was in Connecticut. Both of them involved graduation ceremonies held in these mega churches, evangelical Christian churches, and in both of them, the sanctuaries were replete with religious symbols, and the church immaterials in the churches did not remove either or cover up the symbols or the materials. In the Wisconsin case, the graduation ceremonies at one school had been held in this sanctuary for nearly a decade. A 20-foot Christian cross hangs over the dais on which graduation speakers deliver their remarks and where seniors receive their diplomas. The students and parents would sit in pews lined with Bibles, hymnals, and church promotional materials telling children that they are, quote, God's little lambs, and inviting everybody to return to the church so they can know how to become a Christian. And this particular church was particularly unwelcome to some residents because of the positions it had taken in the community. It condemns atheists as, quote, people who think they are smarter than God, unquote, although some may agree that you are. And it refers to homosexuality as contrary to God's will. In 2009, AU filed a suit on behalf of 9 anonymous district students and their parents and some graduates. The trial court granted the district's motion to dismiss that lawsuit. So AU appealed. The appellate court affirmed the dismissal of the lawsuit by 2-to-1 vote. And some of you may not be aware that in federal court, the appellate court first hears cases by a 3-judge panel. In some cases that have particular public importance, or if the panel that decided that case has taken a position contrary to other cases in the circuit, the entire circuit judges may decide to hear the case what's called en banc. Well, in this case, AU asked the entire appellate court to hear the case. The court did, and last July, the Seventh Circuit sitting en banc ruled in AU's favor, 7-3, that this was unconstitutional. The court said it both conveyed an impermissible message of endorsement of religion and coercively imposed religion upon students. Now, some of you applauded, and AU was very happy about it. Unfortunately, the school district has filed an appeal with the United States Supreme Court. Now, the Supreme Court accepts less than 2% of the thousands of petitions that are filed every year. So we're hopeful that the Supreme Court won't accept the appeal. Of course, we would be happy if the Supreme Court did accept the appeal and affirm the dismissal lawsuit, because that would set a wonderful precedent. But with the current Supreme Court, we're not too sure about that. So hopefully the Supreme Court will not accept that, and that will stand at least for that circuit. And even though the United States has different circuits and our area isn't necessarily bound by ruling in another circuit, still the appellate court sometimes will look to decisions in other circuits. It may not follow them, but at least it's got, they'll probably read the opinion and listen to some of the reasoning made in the other cases, especially when it was so one-sided. The en banc decision, as I said, was 7-3 in this case. Now, a second similar case last year was also filed on behalf of anonymous plaintiffs, students and their parents. They wanted to remain anonymous for obvious reasons. The Schultzes didn't remain anonymous, and they were courageous, but they also suffered the consequences for that choice. In this case, in Connecticut, a 25-foot white cross sits on top of the roof of the church, dominating the skyline as one approaches. To enter the building for graduations, one has to pass under another large cross in the church's facade. The ceremonies take place on a stage under a huge cross set in a stained glass window with religious images, and on either side there are 20-foot long banners saying, "I am God," and "Jesus Christ is Lord." The stage is surrounded by religious images embedded in the carpet as well. And then before the ceremonies begin, I remember I said this was a mega church, they've got jumbo screens saying, "This is God's house where Jesus Christ is Lord." So think about how you would like to feel if you were attending your child's graduation or your grandchild's or whatever, and you had to sit while you were waiting for the ceremony to start, or even during the ceremony, to see these kinds of things displayed at your feet, in the air, and in front of you. Well, in 2009, in response to a letter from AU, actually the school district moved the graduations back to the football fields at the high schools where the graduations had historically been held. But the case didn't end there. A group called Family Institute of Connecticut led a lobbying campaign, and it caused the board to reverse its decision and move the 2010 graduation back to the church. So AU filed a lawsuit with the ACLU on behalf of some of the seniors there. The court held a hearing, and again, this was a little bit longer before graduation in the San Antonio case. There was a little bit more time, but still the graduation was coming up in about a month. So the court held a hearing, and again, ruled in our favor, ordered that the graduations for 2010 could not be held at the church. The schools appealed the case to the Court of Appeals for the Second Circuit, but unlike in the Medina Valley case in San Antonio, the Fifth Circuit, the Second Circuit didn't consider that this was an emergency, did not grant an expedited hearing, and so the trial court's decision stood. So the graduations in 2010 could not be held in the church. 2 years went by, and last year, the parties to this lawsuit agreed to settle the case. And again, it was a settlement in favor of us. Under the terms of the settlement, the schools cannot hold graduation ceremonies in that church in the future. There was a case that AU intervened in, again informally through non-litigation strategies here in the Woodlands. Texas case involved a charter school there that held not just its graduation in a church, but some of its classes in a church. And they had uncovered religious iconography in the common areas used by the school. AU wrote the school complaining about it, and happily the schools agreed to remove all icons that were in the common areas and the classroom areas used by students. And one more instance I'll mention mentioned, our chapter has been working informally with a local college here that has also been holding its ceremonies in church. And we're doing this on the quiet. We're not going to talk about it. Hopefully this will resolve it. The students have actually been working recently with the school administration. And we do hope that they'll be able to convince the school administration that this poses a problem for them. And it won't evolve into a lawsuit. Nobody will ever hear about it. But this is one of the good things about AU, that AU sometimes does work in the background, doesn't publicize its efforts, it just gets results. A second area that AU works in is outside of the schools. AU litigates cases involving government-sponsored prayer, religious displays, and ceremonial religion, as well as public funding of religious institutions, such as through charitable choice or vouchers. I want to talk to you about a few of cases of that nature. First, there are two cases, again, outside Texas that I think are significant, though, involving government-sponsored prayer in front of governmental bodies. Now, y'all might have heard of the phrase legislative prayer. The United States Supreme Court ruled that governmental bodies have the right to have what's called a legislative prayer, which is basically opening the meeting of the governmental body with a prayer, as long as prayer is non-sectarian and doesn't favor or show bias towards a particular religion. So in other words, it can't invoke Jesus' name or Allah, but they can still have a prayer. So what AU has been doing is recognizing, this is what the Supreme Court has said, challenging cases where governments are opening their meetings with a sectarian prayer. The town of Greece, New York has been doing that, in fact, since 1999. It's been inviting clergy to open its meetings with a prayer, and from 99 through the end of 2007, these prayers were delivered exclusively by Christian clergy, and most of the prayers included explicitly Christian language. So AU filed a lawsuit in 2008. 2 years later, as I said, things can take a long time in the court system, the judge dismissed the lawsuit on the motion of the town. So AU appealed to the Court of Appeals, again, the Second Circuit. Last year, victory for us.
Yes.
A panel of the Second Circuit, this was a 3-judge panel, unanimously reversed the district court's decision and held that this practice did violate the Establishment Clause of the First Amendment. This panel pointed out that the board conveyed the impression that town officials identified with the sectarian prayers and that residents in attendance were expected to participate in them, which is a violation of the Establishment Clause. And it held that the town's procedures, quote, virtually ensured a Christian viewpoint, since all of the prayers were by Christian clergy and contained explicitly Christian language. The town asked the Second Circuit to rehear the case en banc. The Second Circuit denied this motion, and now the town has asked the Supreme Court to review the case. In a second case, very similar, arising out of Delaware, that town council opened meetings with the Lord's Prayer. For years, they had done that. AU filed a lawsuit on behalf of 4 residents of the county, including a minister. Again, the defendants asked the judge to dismiss the complaint. This time, though, the district court judge, that is at the lowest level, issued a ruling in favor of the plaintiffs. He said that these prayers did amount to a governmental endorsement of Christianity, and he ordered the council not to recite the Lord's Prayer in front of its meetings while the lawsuit was going on. But he also told the parties to settle the lawsuit, and they did. They settled the lawsuit last September. And it's just kind of interesting. The council agreed that the Lord's Prayer would no longer be recited at the meetings. They said Psalm 23 may be recited, but the plaintiffs may challenge the recitation of this psalm if future factual or legal developments cast doubt on the constitutionality of this practice. Now, in Texas, getting back to Texas last year, there was a case involving the religious displays of crosses on public property. The city of San Antonio had hired a private contractor to build a marker at the entrance to Texas A&M San Antonio. The city paid for it, so it was public taxpayer funds. This tower was built, but the tower featured crosses on each face, just below the seal of Texas A&M. A professor there actually brought it to the attention of AU. AU wrote a letter to the city and to the university explaining it's unconstitutional for the government to affiliate itself with a particular religion by displaying these crosses on what was to be university property. The crosses were removed from the tower, again, victory for AU and for the people who complained. Another case in Texas involved subsidizing a group of religious charter schools. Now, charter schools are being endorsed by some of our legislators right now as an alternative to public schools. One of the problems with charter schools is that they aren't regulated like public schools are. In this particular case, AU investigated a group of 12 charter schools across Texas. They have a campus in Tomball and they have a campus in League City, I believe it is. One of the schools in this system promoted weekly chapel services, offered weekly Bible study classes, and used a religious name and logo. And some of the schools were housed in buildings that also house active congregations. One of them had a graduation ceremony in a church surrounded by religious imagery. And the superintendent of the school system, she's also a pastor. So there were allegations about her using taxpayer money to renovate and upkeep her churches. Oh. There were allegations that some of the school employees were told they had to help with church activities. Some of the church employees or the school employees who were also members of the church got higher salaries than school employees who were not members of the church. And some of the church employees were paid in taxpayer funds. Well, AU got a complaint, did some investigation, and last year asked the Texas Education Agency to investigate the school system. And to its credit, the TEA issued a report that said that there had been some violations of state laws. Now, AU, at the time I did my study, hadn't seen a copy of the entire report, but the part they had read didn't mention the First Amendment violations. So it's kind of a good news, bad news story. At least they said that the complaint had some merit, but it was on other grounds, not the First Amendment grounds. So AU is going to continue investigating this situation. Now, the last type of case I want to talk about has to do with basically discrimination and free expression of religion, and the ability of individuals or groups to discriminate against others based on their religious beliefs. Some religious individuals and groups assert that they have a right to be exempted from certain laws that are meant to protect the civil rights and liberties of others, like employment discrimination laws. And this is called a conscience exemption or a ministerial exception. You might have heard these phrases. AU believes that the right of persons and entities to advance their own religious beliefs or missions has to be balanced with the rights of members of the public to be free from discrimination. Probably the best example of this that you've heard about, at least the one that you've heard about most recently, is the Catholic bishops and the Catholic hierarchy complaining about the mandate in the Affordable Health Care Act that Catholic churches and well, not Catholic churches, because they don't have to, religiously affiliated organizations have to provide health insurance coverage for contraceptives to their employees. And the Catholic hierarchy complains, it's not just, again, the Catholics, this is also Catholic business owners. Some of them have complained this violates the employer's religious beliefs, regardless of the religious beliefs of their employees, who are the ones who are being covered by this. And in fact, some suits have already been filed by some Catholic bishops, as well as Catholic business owners, seeking to invalidate this mandate. Now, AU isn't filing the lawsuits because it's the Catholics who are filing the lawsuits to invalidate the law. But if these cases go up on appeal, I'll bet that AU is going to be involved by filing amicus briefs. And finally, the last topic, this isn't really litigation, but it's a legal matter, involves a violation of the law, and that has to do with church electioneering. Y'all may know that AU has served as the leading voice in the area of trying to educate people about what the law is in this area. And the law is that nonprofit organizations, such as the Humanists, such as AU, and such as churches, cannot participate in partisan politics. They cannot endorse particular candidates. They can't tell other people to try to vote a certain way. They can't do anything that might be perceived as endorsing, supporting, or opposing a political party or a political candidate. And AU sent 60,000 letters last year to congregations from a wide variety of denominations 50 states about this issue. The letters explained what the law was and reminded them about the provisions of the law, barring tax-exempt organizations from politicking, engaging in partisan politics. Well, this season, AU received far more complaints about dubious practices than ever before since it began monitoring church electioneering back in 1992. AU ended up filing 6 complaints with the IRS about church politicking, including 2 from Texas. So Texas, a third of the complaints that came this year came out of Texas. One of them was a church called Church in the Valley, Leahy, Texas, in October. About 2 weeks before the election, the pastor put a sign up on the church marquee saying, quote, and this was in all capital letters, "Vote for the Mormon, not the Muslim!" Exclamation mark. The capitalist, not the communist. Now, AU filed a complaint with the IRS, and actually, apparently, a lot of the townspeople, not just the churchgoers, but a lot of the townspeople supported the pastor. We'll have to see what the IRS thinks about it. The second case coming out of Texas was in El Paso church, a Catholic church, San Rafael Catholic Church. This church in September inserted a statement in its church bulletin that actually it had apparently taken from another publication, but it wasn't attributed at the time it was published in the church bulletin. And this statement asked parishioners to replace our present president with a president that will respect the Catholic Church in this country. And it went on to ask people to pass that along and tell their fellow Catholics to do the same thing. Well, to its credit, the Catholic Diocese of El Paso admitted when confronted that that was inappropriate, that this church had stepped over the line, and it told the pastor of that church to retract his statement, which he did. Now, AU had already filed a complaint with the IRS about it because even if it was retracted, even though the higher ups agreed it was improper, it wasn't proper. So again, we'll see if the IRS acts on that. What lessons can we learn from all of this? Well, you know, we often think that Texans have a mindset different than the rest of the country about these things, and this tells us that no, even in the Northeast, even in California and the Midwest, other people have the same problems with church-state separation as many people here do in Texas, and that's kind of a bad thing. It's a pattern that many of these violations occur in small towns. You don't hear about things like that so much in Houston. Yeah, the Woodlands is a suburb of Houston, but you know, Houston prides itself on diversity and on tolerance. You probably wouldn't get a gathering like this in some of these towns like Castro with over 3,100 people. You might have isolated families there who believe as you do, but the townspeople, since those towns are sometimes insular, sometimes aren't exposed to the diversity of views that we have in big cities such as Houston, sometimes the townspeople not only don't support the plaintiffs, but harass them, make their lives very difficult. That's what's happened in some of these cases. Now, unfortunately, for those of us in Texas, our public officials don't necessarily understand the importance of church-state separation. I have here a link. I was going to see if I could play it. When his computer was shut down due to unexpected weather, I guess, he was going to play that for me, and I don't know, maybe I should have asked you to help me during this speech and pull it up because I'm not sure exactly where I'm going to find it. Let's see. Here it is. Okay. I'm going to see if this is going to work. I'm going to try to play a little bit of this. Uh-oh. I'm not even connected to the internet, so it's not going to work.
I'll get it. Go ahead.
Yeah, set it up for us.
Sure.
I'm hearing the I kind of wanted them to hear this. I'll just kind of give you a little prelude while he's pulling up. I told you a little bit about Attorney General Abbott, and I think those of you, I get the impression that many of you, if not all of you, are pretty informed. You follow what's going on, so you know that the Attorney General maybe wants to be the governor, but Attorney General Abbott isn't necessarily sympathetic to our view of church-state separation. John Cornyn praised the court in the Medina Valley case when the appellate court overturned the trial court's decision. He praised the decision, as did Governor Perry. So here in Texas, unlike in other states, as I said, we have public officials who don't agree with their interpretation of it. And I wanted to what I'll try to do, and if we don't get it, it's okay. I wanted to play you some of Governor Perry's words. You know what, if you can't get it, I can read it. I don't have quite the accent, but you can. Okay. All right.
So great.
Yeah, but I think I got it online.
Work wasn't poured. I was so disappointed.
Okay. He said, this is in a radio interview, the separation of church and state, which has been driven by the secularists to remove those people of faith from the public arena, there is nothing farther from the truth. When you think about our founding fathers, they created this country, our Constitution, the foundation of America upon Judeo-Christian values, biblical values, and this narrative that has been going on, particularly since the 60s, that somehow or another there's this steel wall, this iron curtain, or whatever you want to call it, between the church and people of faith, and this separation of church and state is just false on its face. We have a biblical responsibility to be involved in the public arena, proclaiming God's truth. And he went on, and then he talked about spiritual warfare. Do you have the rest of the quote there? Probably should. There was another part I wanted to read, I've got it here, about Christian warriors. Well, he said that Christian soldiers need to stand up to, you have it? Oh, he said, you think about what has gone here in the last few days around the world, and never has there been a time that I think we need more spiritual courage, that we need more moral fiber, if you will. The American family is under siege. Traditional values are somehow exclusionary. A simple prayer in our public schools is the basis for these secular attacks. You think about this spiritual warfare that's going on, and there's an inaudible part, going strong as President Obama and his cronies in Washington continue their efforts to remove any trace of religion from American life. It falls on us. We truly are Christian warriors, Christian soldiers, and for us as Americans to stand our ground and to firmly send a message to Washington that our nation is about more than just secular laws. Activist courts, we see them chipping away from our values and remove so much that is very special and unique about the United States. And he went on and talked about the Middle East and what's going on there, and he said, our founding fathers knew and understood the importance of the role of our Creator in public discourse. They didn't shy away from referencing Him, using the values He brought and the message of His Son, Jesus Christ, to build the system that we as a society have enjoyed for more than 200 years. He went on to say it's about saving our nation, it's about preserving the values that make us special, about rejecting the concept that freedom of religion means freedom from religion, about turning away from this growing tide of secularism and atheism, the way they preach tolerance and diversity, while they engage in oppression and bullying tactics. So first of all, I hope you are happy. I want to end this on a happy note that you all have an awful lot of power. I don't know how many of you are secularists, how many of atheists, but I know you're free thinkers, and some of you are atheists. And I hope you're happy to know that Governor Perry respects the great amount of power that you have in the country. And the second thing is, I think is ironic, is they being certain religious people, talk about those who stand up for this church-state separation as being oppressors and as being bullies. And yet, it's the Schultzes and the judge in that case who were the ones who were bullied, who were threatened with their very lives. And it's the other families in the other cases who had filed lawsuits anonymously because they didn't want to be subjected to that. It's so ironic that these people who profess to be followers of Christianity, of Christ, and all these great teachings, they are the ones who in turn threaten people's lives, threaten their livelihoods, threaten bodily harm because of religion. I know y'all thought about that. I'm not telling you anything that you haven't thought about before, but I do think it's kind of ironic. One last thing I will say. There is some good news. And that is that, as you've heard in my talk, AU has gotten a lot of positive response to its efforts, not just from some judges, but from school districts, from town councils, from some of the people to whom it writes letters, school boards, school officials, And that's good news. Now, why is it? Well, you know what? We can speculate. It could be because there are some people out there who truly do respect the First Amendment, who do want to do the right thing, and they just didn't know about what was going on. And once they find out, once it's called to their attention, they stop it. And it could be some of the others decide for practical reasons they don't want to be embroiled in a lawsuit. I'm told by my cohort, the president of the San Antonio chapter of AU, that the Medina Valley case had a lot of publicity there. So maybe that's why some of the other towns in the San Antonio area that have been contacted by AU decided whether because they did want to do the right thing or because they didn't want to spend a lot of money that they didn't have, but they decided when they got a letter from AU, they decided to go ahead and follow the law and end the practice that was in question. I don't know, but for whatever reason, we're glad that AU's efforts have been successful, particularly, of course, for us here in Texas. But, you know, as we've heard from our governor and others, these people in leadership, and then people down who aren't leadership, but who we encounter every day, at least we may encounter if we hit the road driving farther outside Houston. There are a lot of people who don't respect church-state separation, don't interpret the way we do, and these are the people who keep AU's legal department very busy. You know, we've all heard since Sandy Hook that the membership of the National Rifle Association zoomed because these people believe firmly in the Second Amendment, and they think the National Rifle Association best represents them and is the best way to preserve the Second Amendment. Well, AU and other organizations like the Humanists believe in the First Amendment. Unfortunately, our supporters don't necessarily join us in the numbers that the Second Amendment supporters join the NRA. But our membership is actually less than the NRA's. AU membership is only $25 a year. So I encourage some of you who have an extra $25, you know, it's the beginning of the year, you don't have to worry about holiday presents, you've probably already given your charitable deductions, whatever you do with your money. Seriously, to consider joining AU. There are a lot of wonderful organizations that people can support, but AU is out there in the trenches, standing up in the courts as well as in the other places, but in the courts to enforce the principles that all of us believe in. Now, Johnny talked about the benefits of joining a humanist. Talked about a magazine you'll have. AU puts out this monthly magazine. I brought a bunch of them in case I needed to refer to them during my talk. But it's a great magazine called Church and State. Y'all can breeze through mine if you'd like to after the talk, as long as you don't run off with them, because I do keep these for reference. But it's one of the benefits that you get if you join AU. And if you just want some more information, I did put a few of these brochures in the back for y'all to pick up. We have one is America a Christian Nation, one is 6 Decades Defending the Church-State Wall, and then this one with Thomas Jefferson's picture on it. Your voice to defend religious freedom for all. If anybody does have any interest in joining, I know some of you have joined recently, if you do have any interest in joining or even finding out more information about us, you can look at our national website, which is www.au.org, very easy to remember, or you can look at our chapter website, which is www.auhouston.org. Just like with the Humanists, if you join locally, you are a member of the national organization, but you automatically become a member of our chapter, so you'll be added to our email list and you'll find out firsthand about all of our activities and things we do. AU isn't quite as active as your organization. Your organization, I see, has more of a social component. But we have an organization, programs that we're proud of. We had some programs last year that we thought were very well received. And again, it's wonderful for me. It's very gratifying to be a part of this organization that has such great leaders as Barry Lynn and such great lawyers as the ones who litigated the cases I talked to you about today. So thanks for listening to me, and I'm happy to try to answer any questions that you may have.
By the way, just real quick, we do have to be out of here by 3 o'clock, but we can do at least a good 15 minutes of at least of Q&A. But do please try to keep the questions brief, 30 seconds or less, preferably. Thank you.
My name is Sid George. I know AU is opposed to school vouchers, but there's a good chance that it might pass in the state legislature. Will your opposition to school vouchers be opposing any public money going to religiously sponsored schools, or will you oppose any religion being taught in these religious sponsored schools?
Well, member of a group called the Coalition for Public Schools.
Yeah.
That's a group that opposes vouchers for various reasons. As you said, AU does oppose vouchers, and in fact, AU has filed lawsuits. I didn't mention because of time, but AU has filed lawsuits in other states challenging vouchers programs, including some cases that are ongoing right now. Opposing vouchers for for religious reasons is probably not the best argument to make in Texas, frankly, and we know that. That doesn't mean that we'll change our principles, but we know that the best argument to be made, the most effective argument to be made, is something like the public schools can't afford it, an economics reason, or the public students who will be left behind to have a growing economy, a better economy in the future. They all need to have a better education. If you take money out of the public schools, then that won't happen. Now, as far as our specific argument, basically AU's argument is that, regarding vouchers, is that they're improper because they violate the state constitutions that have provisions banning public funding of religious institutions. Because the Supreme Court has basically said that vouchers on a federal level are okay. So what AU has been doing is litigating at the state level in those states where they have constitutional provisions barring the state funding or taxpayer funding of religious institutions.
Okay.
Yes, ma'am.
I've heard the argument floated that the courts are turning against us in terms of First Amendment arguments, and so what do you make of that?
Well, the courts have been turning against us for years. And I'll say us, it's AU, ACLU, people who share our point of view. And I think that's really a product of the fact that Ronald Reagan appointed, I think, over half the federal judges when he was president. And since then, both under President Clinton and under President George Bush and now under President Obama, unfortunately, the Congress hasn't been so quick to confirm the judicial appointments of these presidents. And as I mentioned all the presidents because it's gone both ways. It's Congress dragged its feet when they had a Republican president and dragged its feet when there was a Democratic president. It's interesting though because even though the judges have some different, some of them are appointed by conservative or Republican leaders, and you would expect them to be less sympathetic to our principles. Sometimes judges surprise you. On the Supreme Court, Justice Roberts ruled the way he did. I'm sure you all realize that on the Affordable Health Care Act, and Justice Souter turned out not to necessarily be what was George Bush thought when he appointed him. So it's hard to say. The climate here in Texas is not particularly sympathetic. But then you know what? Every now and then you get a good decision, whether it's at the district court level or the Fifth Circuit level. So yeah, it is. I have heard by those who do this work every day and know a lot more than I do about the courts that there are concerns about the way the United States Supreme Court might rule on some of these issues, and that's why, first of all, organizations like AU carefully select which cases they're going to litigate. They may choose to litigate a case on very similar facts in, for example, the Second Circuit, and choose not to litigate that same case here in Texas because the Second Circuit has issued some decisions that have been more favorable than the Fifth Circuit has. That's definitely consideration when the lawyers on staff make these decisions. Who knows though? I mean, I was thinking about this morning. They say now that almost anybody can get elected president by an atheist. Gay people, people of color, women have all made strides through the years. Even people in minority religions. A Mormon ran for president, and although people thought it was going to be controversial, still, I don't think that's why he was defeated. I think it's going to be a long time before an atheist or a humanist or a person like that is going to be elected to anything. But who knows? Maybe in the next 50 to 100 years, maybe that'll be the next group whose civil rights are respected. I don't know.
Has AU filed a complaint about the prayer at the inauguration of President Obama? Let me finish. At his first inauguration, he welcomed people of all faiths and people of no faiths as Americans. This time, the last prayer, I don't know whether it was by a rabbi or I don't think a rabbi had done the prayer before that, but his closing prayer said, they prayed to God to bless our leaders, because without God, they would be evil men without moral truth. In other words, he wrote out free thinkers as part of those whom the government should accept and protect. Did you hear that?
Well, I heard, what struck me about the inauguration was both the invocation and benediction were led by, I guess, priest or pastor, well, Miss, what's her name? Nedgar Evans, Wiley, whatever her name. She did the invocation, and I think it was a Catholic priest did the benediction. Anyway, what I was struck by was both of them referring to praying in Jesus' name. And I have thought about I thought about this issue, and I looked at AU's website last night, and there was nothing on there indicating whether they're going to complain about it. There was an article on the blog written by whether they're, you asked if AU's going to make a complaint, right, or file a lawsuit over that. Your question was if AU's going to
unless someone else complains
right.
to you.
And I haven't seen that AU itself has filed a complaint or written anything on it, but that inauguration was only not very long ago, just about a week ago. Less than a week, I guess. This week, as a matter of fact. But Rob Boston, who's an AU official, wrote a piece before the inauguration questioning why they have prayers anyway. He said that prayers were, I think he said prayers were included or added to the inauguration ceremony back in the 30s, I believe, so it's not like it's been back since the inception of this country. I don't know if AU will take that on. While I think many of us would probably agree with you that it was definitely inappropriate, or terrible, yeah. I think that to be pragmatic, AU doesn't have a real big staff and has to pick and choose which cases it's going to take on. And so I'm not about to speak for AU. I don't know what AU might do, but although I have a feeling people on AU staff would agree with you that it was terrible, I'm not sure that AU would choose that fight.
Just complain. I've been a member of AU for many, many years. Of course, the court, everything it does, it's one organization, very limited, almost the same. I think this is one particularly outstanding, egregious violation of the Amendment.
I agree. I agree. I agree, and I hope AU will say something about it. The forum AU will choose, I don't know. I mean, you can do what I do, check AU's website and monitor it, or maybe it'll be mentioned in the next issue of Church State Magazine. This January one had a picture of the president and his wife from the first inauguration on the cover, because they were talking about potential challenges of church and state in this next administration. So, you might want to look at your next issue of Church State Magazine to see if it mentions that, and see what, if anything, you chose to do about it. Yes, ma'am.
Prior to the recent election, there was some news that I caught that there were some ministers who intended, and were speaking out beforehand, who intended to endorse a candidate from the pulpit, and they dared to be taken to the Supreme, they wanted to be taken before the Supreme Court to show that it was illegal to hold their opinions. Whatever came of that? I heard that they were going to do it, they probably did do it, and then what?
Well, some of them did do it. I think probably the most blatant ones that you would file complaints about. But, the vast majority, polls have shown that the vast majority of Americans do not want their religious leaders, their clergy, to take positions from the pulpit. They can take positions about candidates as private citizens if they want to, but not from the pulpit. So there was a campaign led by a group called Alliance Defending Freedom, I think is its name. It used to be called the Alliance Defense Fund. So yes, there was a group that led that effort. I'm not sure how much support it got, because most clergy are more conservative, I don't mean politically, but I mean, they don't wanna get out there and do anything that's going to jeopardize their tax status of the church, nor frankly, do they want to, most of them create divisiveness among their congregations. Most of them recognize that their congregations are made up of people of various political stripes, and they don't want to have the church be seen as a place people should come and have another source of conflict. So to answer your question directly, yes, I'm aware of the campaign. AU was aware of it, and AU warned clergy to be careful about what they said and what they did. And so I'm really not sure if we're going to see any more fallout from that or not. Yes, ma'am.
The mention you had about the lawsuit that the Catholic bishops were filing trying to get out of the contraception coverage, I thought that had already been addressed, and basically it's not an issue because the healthcare now says, well, you know, if you're a religious organization, the insurance company will pay for it for free, and you're not even involved in it. I don't see how they have any standing.
Well, you may think that, but they think differently.
But I mean, they're not.
No, but seriously, that the Obama administration tried to come out. And my understanding is the law says if you're a religious organization like a church, you can be exempted. But also they made the accommodation that you just talked about, but that apparently wasn't enough.
But they're not being, you know, they're not being forced. They're trying to say they're being forced to pay for contraceptive. They're not.
I guess it's indirect, they're saying, because it's their insurance policy that covers their employees, and they don't believe that their employees should have access to birth control because that's in violation of their religious beliefs. So their position is that they're the Catholic hierarchies or Catholic organizations, religious beliefs are paramount.
I mean, you can't force your religion on somebody else's
Well,
throat.
you're giving AU's material and you're reciting it to the rest of the class. I agree.
All right, if we could just do one more question.
You had your hand up, sir.
All right, thank you. What is the statute of limitations on filing suit in the federal court charging an entity with discrimination?
You know, that's a good question. I don't know the answer to it. It depends on specific law. I think it's probably 2 years, but I'm not exactly sure. I mean, I certainly could look that up and let you know, but I'm not
Okay.
sure. Because it's a federal statute. Most of these are federal cases based on federal statutes. Are you talking like, say, employment discrimination or religious discrimination?
Discrimination in the workforce.
Yeah.
Yeah.
It's a federal statute, and I think it's 2 years, but I'm not sure.
Okay.
If you want me to take your name afterwards and find out, email you on that.
Right, let's do that.
Okay.
All right, well, if we could give a hand again to our speaker.